My name is Lindsay Olivarez. I'm one of the family law attorneys here at Udall Shumway. In my work with clients, I'm often asked, what can I do to change a parenting time or legal decision-making decree as a result of a dissolution, legal separation, or paternity judgment? In most cases, you'll see in your parenting plan that you actually have a requirement before filing a petition to modify to go to mediation to try and resolve the issue. Now, this mediation requirement does not apply if there is a true life or limb type emergency to a child. So if there's an emergent issue, then obviously you'll need to file for your own emergency orders to modify the parenting time. If there's not such an emergency, the first step is typically going to be through mediation. I'm then asked, where do I go for mediation? You have a couple of options. First, you can go to private mediation. You can secure the services of a private mediator out in the community among attorneys and pay for their services and use their services to try and reach an agreement. Generally speaking, the cooperation of the other party is going to be required because there's no mechanism to force that person to show up at a time and day for mediation or to even participate in the payment for the mediation, depending on the terms of your decree. If you are concerned about whether someone's going to be cooperative in proceeding to mediation, then you always have the option of proceeding with the court's Conciliation Services Parents Mediation. This is a very simple process. The forms are available to you online, and generally I recommend that you go ahead and do that process on your own after consulting with an attorney to find out how you're going to define what you need to be speaking about in mediation. But it gets the process started, and you actually don't need the services of an attorney to just file that simple document. Now, parents mediation does not include attorneys. Private mediation certainly can and typically does. But the parents mediation through Conciliation Services has the benefit of being inexpensive. It's generally only $100 per party. It is also quick. They typically set you within 6 to 8 weeks of a request. And you also have the benefit of forcing that person that you're not sure about their cooperation level to the table to talk. They actually have an order to appear that must be served upon them, that you receive, that you then serve. And they have to be there. Now, if they aren't there, if they don't show up, there is a mechanism for enforcement. Now, no one can actually force someone to come into a room and sit down and try to work things out, but if they don't show, they are subject to a fine. And that fine is typically $100, or it can be $200 if the other party did show up. So that's the impetus, in other words, to get someone in the doors, to avoid that kind of a fine. And hopefully through that process you work things out. Whether it's by private mediation or through Conciliation Services, any type of agreement that's reached should be reduced to writing and signed between both parties. Before you approach the idea of mediation, either through Conciliation Services or through private mediation, certainly you'll want to consult with an attorney that you're not considering using as a mediator, as such would be a conflict, before you actually reach out and start that process. That way you have an idea of a strategy in terms of what your goals are and how to achieve those goals, and you'll be better knowledgeable about how you can actually work through the process and what your results might be.